Dear participants, dear friends, welcome to our 8th Global Digital Encounter dedicated to the artificial intelligence and data-led revolution that affects profoundly intellectual property. This encounter, organized by TIPSA and the FIDE Foundation, bring us to a key element for our future and how intellectual property will react to it. This is an encounter that has been much looked forward over the last months. We started the Global Digital Encounter project in May. The Transatlantic IP Academy that I had the honor to chair and the FIDE Foundation decided to organize jointly this program of global digital encounters on IP in the post-COVID world. As such, we already touched artificial intelligence on several occasions at our inaugural conference in May, but also in another encounter dedicated to patents. This time, we are focusing on copyright-related matters. We are focusing on it with participants all over the world. We are together, we have hundreds of participants from all continents who really want to learn more from worldwide authorities, from worldwide glories of academia in intellectual property. We are very happy that our sponsors have supported us throughout the past year and again this year. This is really a voluntary work that we are doing, FIDE Foundation and the Transatlantic IP Academy. So we are very, very proud to have received a very, very large support for this. Our presentation today, our encounter, for which we count on your very active participation, will have as panelists Daniel Gervais, Professor Daniel Gervais from Vanderbilt University, where he directs the IP Center. I don't think that I should present Daniel Gervais, who is a worldwide glory in the field of intellectual property, and as such has worked in senior positions for WIPO, for CSAC. He's also a glory in the field of copyright, a part of being the former president of ATRIP, just as our colleague, Professor Christophe GEIGER from CEIPI in Strasbourg has also been president of ATRIP, and is, just as Daniel Gervais is very active in advising international organizations on better lawmaking in the field of copyright, including data mining, intellectual property in general, and of course, artificial intelligence. The present conference will be moderated by a star and rising star of intellectual property, Dr. Ulrika WENNERSTEN from the University of Lund. She brings Scandinavian and European excellence in the field of artificial intelligence and has been one of the organizers of one of the most prestigious conferences of the past years in the field of intellectual property and artificial intelligence. And as such, her research, her talents make her the ideal moderator for today's session. In today's session, we shall focus on AI output and also AI input and AI enforcement. These will be the three directions that we will cover. As such, AI as a creator, what is AI as a creator and how does it relate to intellectual property? AI, how is AI fed? And therefore data mining is so important. And also how automatic enforcement mechanism will play a key role. But before leaving the floor to our three key stars today, I would really wish to pass on the floor to Javier Fernandez Lasqueti, who is the coordinator of the encounter under the co-direction of Professor Manuel de Santos, who is with me, the co-director of these encounters, Professor Manuel de Santos from Alicante University, whereas our coordinator, Javier Fernandez Laschetti, comes from IE and is also a worldwide known professional of intellectual property. My friend Manolo de Santos and myself welcome you warmly, wish all of you and greet all of you for this new year, hoping that it will be a better year and a good year for a fair IP under a revolution that is taking place, the one of artificial intelligence. The floor is yours, Javier.
Thank you very much, Laurent, and thank you to you all for coming to this 8th encounter. We wish you all a happy new year and our best wishes for this year, and that we hope will be much better than the 2020 we have passed. And we are very happy to have here these professors to speak about this so important issue, such as the crossing between artificial intelligence and copyright in this new data-led economy, and this new data economy that is coming is now present. Just to remind you that you are member of the community, so you are most welcome. If you want to raise questions, you want to share with us information, because this is more than a webinar. This is a community, this is an encounter, and this is a community in which we would like you to participate. So welcome again in these 2021 sessions, and thank you for being here. That's all I wanted to say, and I pass the floor to you again, Laurent. Yeah, Laurent.
Well, I would pass, thank you very much, Javier. I would pass on the floor to Ulrika, but before, I would really wish to mention that not only, as Javier has mentioned, this is not only 1 hour, 70 minutes presentation, but there is also a list of readings for further in-depth knowledge on artificial intelligence and intellectual property that our speakers and moderator have kindly prepared for you. There is a chat, and we are awaiting for your questions. Our template of the global encounter is not a monologue, and this is really where we want you on board to create with us, in this case, not to create artificially. Dr. Ulrika Wennersten. Ulrika, my friend, the floor is yours.
Thank you so much. Thank you for the presentation, Laurent and Javier. It was very nice. Thank you. I think that we can start this encounter with concluding that perhaps last year the most discussed topic was actually AI and intellectual property, and also AI and copyright. I think also that I just want to highlight something also in the beginning, that the European Parliament, as you know, all know, then adopted a resolution on IP rights for the development of AI and technology in October. And also I want to mention the report that the European Commission published in November, where Danielle was one of the authors also. You can find it in the reading list also. And I also, before we start, want to recommend actually an exhibition, if you haven't seen it, on WIPO's homepage, where you actually can go and look for different kinds of work that is created by AI. So it's quite a nice exhibition, I think. So we all know that copyright actually has been able to adapt to the technological revolution for 150 years. But the question is, can it adapt to the technical revolution with AI? And I will start then with some questions on how to treat the output. And also I will then say something. My first question is actually about total autonomous creators. If we then look at today's copyright, could actually output that is created by a totally autonomous AI be protected by copyright? If we look to the concept of originality, the moral rights, the justification and rationals, duration, and so on. Daniel, do you have any input on this?
Yes, thank you, Ulrika, and thank you for the organizers for putting together this encounter. I think that's very timely. Nice way to start the year. Perhaps the next encounter on this subject, you can have a robot explaining some of it. So the question is one that we're approaching, of course, as lawyers or legal scholars. I think this is the case of most of the people on the call. And as lawyers, we're trained to think by analogy. And here this would be really my overarching point on this output question. We're dealing with something that is actually unprecedented. So I'm happy you mentioned 150 years of history. You know, there was the revolution of software protection by copyright in a way, and then there was this so-called revolution of autonomous creation by some sort of random generators in the 1970s and 1980s. And my point is really this AI phenomenon is unprecedented. Why? Well, let's look at originality, for example, that you mentioned. In the EU, according to the Court of Justice, in the US, and in many other jurisdictions, originality, which is a worldwide notion, is defined as the result of creative choices. And for the first time, really for the first time in history, we have to ask seriously whether a machine can make choices that are creative, because AI machines do make choices. That is, as far as I'm concerned, unquestionable. The question is not the choices, but the creativity of the choices. And here we can do a couple of different things. And one of the papers I gave in the reading list goes over this. There are some doctrinal questions, so you can look at creativity from a doctrinal point of view. But I would like to ask a more fundamental question as we're getting started, which is, why would the machine creations deserve copyright protection? So I'm starting with a much more normative question. Why would they deserve a moral right, for example? Now, the last point I can make as an introductory point is I've read a lot of people saying, well, it's not really the machine, there's a human proxy somewhere. It's like work made for hire in the US, or this corporate authorship, which, in many countries, if there's an encyclopedia created by a whole bunch of people, there'll be some legal entity perhaps that will be considered as the first owner of copyright. But my point here would be this, and it's quite simple. What we're dealing with is exactly the opposite. Let me explain that very quickly. In a work made for hire, which is a situation, for example, under US law, where a film studio will be considered as the author of a movie, even though the studio is nothing, it's a legal entity. Or in the case of an encyclopedia, where the law says, well, the first owner of copyright is the organizer of this encyclopedia, who might be a corporation. What you have is originality being transferred from actual human authors to this legal entity, right? In the case of AI, it's exactly the opposite. It's a machine creativity that people say, well, we can transfer that to a human. And that's why I ask, why? Shouldn't we ask the people who are saying that these machine creations deserve some sort of protection to give us some reasons? And I go in my paper over some of the reasons, and I at this point haven't found many of them convincing. So I'll stop here, but that's kind of my first point.
Thank you so much. I actually agree with everything you said, and when it comes to autonomous AI, firstly, I think that we can also conclude that it's, in the future, so it's not around the corner today, but today at least we can use AI as more like a tool, so you could have it instead of like a computer or a brush, or you could have an AI as autonomous, and then you have some sort of a sliding scale from this tool and brush until you have this totally autonomous. But do you think that all these different way to create should be handled in the same way legally?
No, not at all. I think there's a sliding scale. I think is the right expression. So if you take the very easy case of somebody using Word to write a novel, there's no question that Microsoft is not, a co-author of the novel because they made the software. Why? Because the software really doesn't make creative choices for you. It makes some choices, formatting choices, and a few others. It might suggest words in the thesaurus, for example, but it doesn't reach a threshold. AI, I'm not sure, has reached the point where it can actually autonomously make full, creative choices. That's debatable as a matter of technology, but what, to my mind, is not debatable. It's just a matter of time. And so examples of movies created with, CGI, computer-generated images. I heard of software recently that you can send you feed it a novel and it gives you suggestions on how to improve your novel. Those are functions that are really approaching co-authorship level if they were performed by a human. And so at some point we need to be prepared to cross the line. Perhaps we have crossed the line. You mentioned the WIPO exhibit, so perhaps we have crossed the line. At this point, so in the European study that you mentioned, the European Commission study, we went over very carefully the examples that people referred to, like the new Rembrandt, for example, that were created by an AI machine. In all those cases, we found a lot of human involvement still. So I don't think we need to overhype the power of AI to create in 2020 or early 2021. But it's a matter of time before something happens which will really look like an autonomous creation where there will be no human cause, really. It will be a machine creation, and then we will squarely have to answer the question, does this work, if we want to call it that, deserve copyright protection? So yes, it's a sliding scale, and I think it moves as time moves, the ability of machines will continue to increase.
So if we look then, for example, what do you think, when is actually, if you look at the process when you actually are creating something within AI, where in the process could you actually say that you could have some sort of protection? Is it like when you select the input, or is it like if you do something with output, or?
I think so. If you do that's a great question, because if you look at the output, there's this thing in AI called the Turing Test. I don't know if you're familiar with it. Maybe some of our people on the call are familiar with it. So this was an old from 40 years ago or so, 50. The idea was two people. One person was chatting with a screen, and on the other end of the screen was either a computer or a person. And the person who was chatting had to decide whether he or she was chatting with an AI or machine or with a human. And if the machine was able to fool you into thinking that it was a human, it passed the so-called Turing test. I'm simplifying, but that's the general idea. And I don't know why in law we would say, well, if you the machine, fool us into thinking that this was a human creation, you should get rights. That to me is not a convincing argument. You don't kind of pass yourself off as human and say, I have rights because I can pretend to be human. Not that the machine would claim rights, but that's the gist of that. So I much prefer to look at on the input side and then say, in my paper, I call it the human cause. Why? Because in law, again, as I said earlier, we like analogies, and the notion of cause is well known in all legal systems, right? So are you responsible? Are you liable for something you did? The law will look at whether you're the cause. And I'm saying this notion is very appropriate here. Is there a human cause? And the way you do that is you say, where are the humans in the big picture of this creation process? So you look at one particular, say the Rembrandt painting. Okay, it looks like it was created by a machine, but then you look, behind the screen, so to speak, and then you see there are humans who really were closely involved, and you say, there's a human cause. but we're going to reach a point where there's no human caused, that the work created by the machine is not caused by humans, in the sense that the humans could absolutely not foresee that they were really not linked to this work in any way, shape, or form. And then I think on the input side, we will have some really hard questions. But I think, for example, courts could apply the cause, the notion of cause here usefully, and say, who caused this work? Was it a machine, or was it a human, or was it both? And this, then we're back to the sliding scale, right? So.
Yeah, and I also was thinking about the, so if we can conclude that with this sliding scale, that if we then can see it more like a tool, then maybe if we, for example, apply the Painter case and so on, then it might be that we actually can protect it. But on the other hand, the more autonomous it becomes, the more unlikely is it that it actually will get protection. But how about then, could we maybe protect it by related rights instead?
Well, so your question in a way assumes that it should have protection. And of course, I start with the premise that if you say it should be protected, you'll have to show me why. I'm really asking why. And I looked at the history of copyright in my article to say there was always a human cause to these works. In fact, that's why we have them all right. That's why, in fact, we have copyright. We wanted to protect the authors as authors because we value what they do for us as a society, right? So whether it's copyright or related, so the related right argument I understand, because related rights, what's the difference really fundamentally between a related right and copyright is there's no originality in related rights. So, okay, so that avoids the big question as a doctrinal matter. But I'm back to my normative question. Why would we protect these works? Let me give you one argument, at least to think about. If you're a film studio or a record company, wouldn't it be great to get rid of all these expensive human creators on your payroll? Now, as a species, and here is a really serious question, as a human species, are we better off having machines do the, write the novels, write the music, make the movies? This is quintessentially why we're humans. We communicate with each other. That's kind of the highest thing we can achieve as a species. And we're going to offload that to machines. I'm not saying we can prevent that. Maybe the technology can not be stopped. It will just happen no matter what. But I am saying, let's not make it easier for the machines. Let's not create additional legal incentives to accelerate the human extinction from the creative sphere or replacement. Perhaps extinction is a little strong, but I'm trying to make the point quickly. So yes, related rights are an easier doctrinal route, but they don't solve the normative question. I think Christophe might actually want to chime in on this one because I think he's got a lot to say on the related rights issue as well.
Yes, thank you, Daniel, for passing me the floor. Actually, I would also like to, because I'm just it's my first time speaking, thank the organizers for giving me the opportunity to speak on this topic, which is in fact a lot discussed. I would just like to say about the related right, my position here would be a call for caution. Why is it so? It seems that every time there is some sort of a new technology or new immaterial asset that emerges, there is always a call for some sort of IP right. So we have discussed copyright. I'm totally in line with Danielle on this one. And on the position of many other scholars, such as Jane Ginsburg, which in editorial in 2018 in the ISC actually put it very, very simple. Copyright is about people, not machine. I mean, it's very simple, but it says a lot actually. And for the better and more profound explanation, Danielle really put it very clearly. So if we don't protect by copyright, so what are the options? Of course, neighboring rights, sui generis rights when we don't know really in what category we have to put it. It's what it's called. I would really call for caution, also because we are not really sure of the expected result of such a right. In particular, when we look at the history of the related right that we have had, particularly in the European Union, where we create these rights very easily. The problem that we have is once these rights are out there, it's very complicated to get rid of them. So before we kind of experience and just create something that will stick for us forever and maybe have really detrimental effect at the end on the on AI production or creativity in more general or innovation, then we should really assess what would be the merit. And Danielle has very clearly pointed out that we need to find an added value with creating this neighboring right. What I see at the moment is most of the time, like industries that are a bit on the decline, such as a press publisher in the online world, for example, claim to have some investment protection, and investment protection becomes a new rationale for creating neighboring rights. And of course, in the context of AI, it's obvious there are some investment which are made. But the question is here, what would be the consequence on follow-on creativity? Imagine all these works protected by neighboring rights, millions of potential works protected by neighboring rights. The transaction costs would be the same than with copyright, basically. But the problem is what would be left, what is the creative space that will be left for creators that come afterwards and that will face all these millions of rights. I'm not talking about the clearance of this right, which actually would be a nightmare. But in the absence in Europe, and particularly of such a flexible exception for creative use, or that is very much discussed at the moment, creating neighboring rights might actually have a blocking effect on creativity. And I think we should really assess the merit very closely before we create such a right that would stick forever. We have a very good example, and we've been talking with Danielle, with the database right that was created in 2006. And I remember at that time, the database industry in Europe was saying, if you don't give us a neighboring right, there will be no database created in Europe. And we know that there are a lot of other jurisdictions that made a different choice, didn't protect by neighboring rights, and also have a database flourishing database industries. We also know that, for example, this database right has created a lot of case laws that's very complicated, etc., and has been evaluated by the European Commission twice, and they didn't find any merit resulting from this specific investment protection on database creativity. So if you ask me, should we go for a neighboring right or a sui generis right? Well, at the moment where some scholars, such as Bernd Hugenholz, write also in the IISc, neighboring rights are obsolete, I think we should think twice before we go down that route.
Thank you. But then my question is, of course, also, but the scholars that actually argue from some sort of protection, they argue that we have to have the incentive, we have to have it because of competition, because otherwise we lack other behind other countries that actually protects and so on. But could we agree internationally? Do you think on maybe leave it in the public domain?
Is that for me, Christophe? Please. Well, so I think internationally, the answer is actually not horribly complicated. Sam Ricketson, that most people probably know, the author of the co-author of the leading book on the Berne Convention, said very clearly that copyright is about human authorship. I don't know of any court anywhere in the world that has now said, oh, it doesn't matter if the machine's the author. We have courts in the patent sector that have now started to say, well, a machine cannot be an inventor for patent law. and that is not nowhere near the requirement of human input that is traditionally been part of copyright. So on the investment question, though, I would say the incentive question is really usually not framed very well. People say, yes, we need an incentive. Okay, for what? If you mean an incentive to develop the technology to create the works, we already have an incentive. Some of it might be patented. The AI code written by humans is definitely protectable by copyright as a literary work. We've known that for 40 years or more. So there's an incentive. So then what you're really saying when you say you need an incentive is we need to give the machine an incentive to run its code. No. Or you're asking, well, should we give an incentive in the form of IP rights to the people who are teaching the machine, the so-called machine learning function? That's a much harder question because feeding data into a machine has not traditionally been an operation that results in copyright or patent rights, that again I have not seen an economic case, or I haven't seen a case made. Look at the development of the AI industry right now. It is phenomenal. There is no such right. Perhaps there's a trade secret right that you can rely on if you have secret data sets that you can, but in Europe, perhaps there's a database, right? I don't think Europe is way ahead of everybody else in AI because they have a database, right? If anything, it might be the other way around. So I'm really not sure the case has been made for an incentive either on the machine doesn't need an incentive. So then the question is, okay, so and there's an incentive to develop the machine itself, as I said before. Beyond that, I really question, do we need an incentive to have the machines replace humans faster at the one thing that defines us most as people, which is our ability to express ourselves and communicate with one another? And there I am really, really hesitant.
Do you want to also say something, Christophe, on the topic?
No, because actually I totally agree on what Danielle just said. Sorry to be boring on this one, but yeah, it's obvious, and we should not really be so scared of not protecting. I mean, we would. Well, first there is also some like software protection for developers of AI software, etc. So there is some sort of a protection that is out there, and we can also think of maybe some unfair competition issues. And it's not like there is no legal protection. The question is, should we go for IP rights? And we know also the potential of IP rights in terms of blocking effect on a dynamic market. So basically, no, I totally agree, and we should also maybe try to learn from our past experience. I was just mentioning in Europe some misguided developments that had led to a lot of very difficult and untransparent legislation. Before we act this way, we should really, as Danielle has just said, leave a little bit the market develop and observe, right, before we intervene.
But should we be scared of all this kind of output that the machine actually produce? If you look at the exhibition, the WEIPI exhibition, and they produce music, they produce arts and so on. Should we be scared of what all this output could do, like with the room for, as Christophe mentioned before, the room for creativity, the human creativity? Do the human creativity becomes the possibility to do something as human becomes smaller in a sense?
Not if you don't protect it and leave it in the public domain. So
yeah, I tend to, I mean, I certainly agree. I think my point is we can't prevent it. People will develop these machines. but why would we create incentives for these machines to replace human creators? I don't see why that would be helpful for anyone, except maybe the people who own the machine. But as a society, are we better off doing that? I have not heard a good case for it. I've heard the expression, well, we need to protect the works because the author of the author is a human, right? Think about that. That's why I say this argument is wrong when you look at the cause. We're saying, it's like saying, well, we should give a right to Mozart's parents. I'm sorry, no. The answer is no. There's no, the cause there is, yes, this biological cause, but the work, the piano concerto written by Mozart was not written by his parents. So that's why we need to look at the cause. And when I look at these works on the WIPO website, first of all, you'd have to look at the machine learning process to see exactly how autonomous these creations were. And again, when we looked for the European study, we really found a lot of human input. Of course, for the press release, it's better to say, well, there was no human, it's all autonomous, but maybe not quite. And again, I don't know as a fact. I would have to check. But why would we want more of these and fewer works created by actual painters, human painters, or human artists? Or there are YouTube channels now with music created entirely, at least according to what it says on the channel, by machines. It's not fantastic, but again, it's a matter of time before it gets better and better. Do we want all the songwriters to do something else? Do we want, remember the thing that how do you become a painter? How do you become a songwriter? Very often you're taught by people who've done it for decades. You're mentored. Well, if we get rid of the people doing it now, of course, there will be no one to mentor on either side, no mentors, no mentees, right? The whole thing goes away. And I'm just saying, let's just be, as Christophe said, let's just be very cautious before we create a legal incentive to make that happen faster.
I might just add something, if I may, Ulrika.
Of course.
Yeah,
of course.
Actually, it's not really serving the purpose of this encounter, but I think maybe we should focus less on artificial intelligence and copyright, and rather focus a little bit more on the situation of creators, and particularly in this pandemic crisis, which are really suffering because they cannot give concerts, and their copyright system is not really actually working so much for them. So this might be maybe a call for policymakers to get the priorities right. And if we want creativity and we want human creators, well, right now you cannot go and produce big concerts, but maybe you can fix a little bit of the copyright system by giving them a better share of the cake. I know the European Union has tried to make a great step in this direction in 2019 by adding some contractual copyright contractual law provisions that protect creators better. But we know there's still a long way to go, and this should be also a focus in the context of AI. I'm a bit, you said it, Ulrika, yourself, I'm a bit worried that we kind of focus all our attentions on this, while there are some huge issues on the policy agenda that are totally forgotten at the moment because we focus on AI and the potential protection of IP that we might give them. If we want creativity, we will still need to have some artists out there. And at least in Europe, we have great output from physical artists that we should not forget.
Yeah, and that is actually a good way to move over to the input, because one other question is, of course, to feed an AI, we have to use work in a lot of cases. But will there actually be an infringement when you are using these works to feed the AI, the input? And also, is any of the exceptional limitations we can see today, at least in the European context, can we use them? And also I want to ask then, We have soon, in June, also a new limitation on text and data mining. Would that be relevant in this context?
This for
Christophe.
Yeah.
Okay. Well, thank you, Ulrika. I think actually you were saying in your introduction that last year was the most discussed topic was AI and IP, and I actually spent my entire year last year by advocating that basically the European Union has really missed a major point when it comes to, if they want to promote efficiently AI, then we need to have robust and well-functioning exception for text and data mining. And you really have pointed out this fact. I mean, none of the policy documents that we have seen recently, be it the communication from the Commission on Artificial Intelligence, the ambitious package that was published in February last year, where AI will save Europe from drowning in this very difficult time. The action plan that was published by the Commission just before Christmas in November, they all mention artificial intelligence, but they totally forget that there are some exception limitations that are absolutely crucial when it comes to make AI functioning. If you feed, as you said, an AI with works, you have to be able to search a huge body of existing works, and this is absolutely crucial in order to have a functioning AI algorithm. So, and it particularly, by the way, also because one of the title of this series is in IP in the post-crisis world. I mean, also to search to develop new vaccine, you have to do text and data mining, and basically all the vaccines that have been developed were due to functioning text and data mining. But the exception limitation that were passed last year by the European Commission, we can go more into detail if you want, are so narrow in their application, with a lot of different carve-outs, opt-outs, etc., that they do not allow basically startups to feed the AI with works, but they also don't allow them basically to search. And that is, I think, a major problem, because the right to research is, I think, one of our core fundamental rights. This leads to innovation. It's protected by the European Charter, by the European Convention on Human Rights, by the Universal Declaration on Human Rights, and the right to search from objective and existing sources should definitely be something that we put at the core of our policy when it comes to develop AI, but also maybe vaccines or research in general. I think we all researchers, we know that we use text and data mining to when we go through different publications. So in short, I would say here is absolutely a missed point in the debate about artificial intelligence, not sufficiently look at text and data mining exceptions.
And also a follow-up question, because as I understand, if we look around the world, the text and data mining limitations looks differently. And if we then have a very limited right to, or right in the sense as the European Court of Justice has said that it's actually our rights, the exceptional limitations. How about collaboration across the world in research?
I'm happy. Yeah, I'm happy to reply. Of course, I don't think we'd even have to make it global. Take the European Union and 27 different copyright laws and different copyright exceptions, while we have to constantly put application for grants which involve at least researchers in several countries, different countries. How can they basically collaborate together when they don't have the same scope of and this was one of the aim of the copyright directive. Unfortunately, as basically like in 2001 with the InfoSoc directive, there are some really complicated compromises. Some ambitious provisions were created and then taken away by some reference to particularly technical solution, opt-outs, carve-outs, referring to best practices that needs to be negotiated, etc. This would certainly not foster legal security and thus creates a huge uncertainty for a lot of pan-European research projects.
So one question from the audience is then, do you think that the exception for the text and data mining will expand post-COVID for the mentioned reason?
Daniel, maybe?
Yes, of course. Well, first of all, I agree with Christophe, and as much as I'm a skeptic when it comes to replacing human creators with AI, I recognize the power of AI to do one thing much better than humans, which is to go through a lot of data and find correlations and all those things. It does that a lot better than any one of us, or at least it can. And so I'm very much in favor of letting the machines learn. So the question of the copyrighted, the copyright in the output is a very small subset of AI. The bulk of AI is developing in areas like pharmaceutical research and other areas. So I absolutely agree. In the US, of course, you can look at, there's no direct precedent at the court level yet that I could cite to, but the Google Books precedent in the Second Circuit, which allowed Google to scan copyright books that were still protected by copyright, to give access to snippets, which was found to be fair use, is an interesting, potentially relevant precedent here. I think, companies that do AI will need to be in an environment where they feel safe that the machine can learn without, being sued for copyright infringement. And the same way that I asked at the beginning, why should we give copyright to machine creations? I would say, again, why would we prevent machine learning by copyright? So each time somebody says, well, copyright needs to apply to something, you can see my reaction is to say, well, are we sure that the outcomes will be better? And the answer is not always yes. Sometimes it's obviously necessary, but not always. So if we have different protection, we may end up with, if I can make a parallel with data privacy, where you see now the US and Europe basically having this war of standards on what is proper protection of personal data. Will we end up with the same thing for text and data mining and copyright? That would not be optimal, but it wouldn't be entirely surprising.
If I can add just one point on this, I think if text and data mining would expand, would necessitate two things, at least in the European Union. It would either we revise the copyright directive on text and data mining, which I think would make sense in the future. And this can very easily be done with regard within the action plan on AI. And then it could be also an issue at international level. We know that exception limitations are on the agenda of WIPO. It might be wishful thinking, but the crisis has given us the opportunity to revise some certainties that we have. And I think at WIPO, within the context of exception limitation for education and research, we could introduce this discussion on text and data mining. Another aspect would be to take the provision that we have right now in the European Union and try to interpret them in a fundamental rights compliant manner. I'm just sorry to be a bit technical, but we have two different provisions in the directive, one for research organization and one potentially broader exception that could apply to all kind of actors, including startups. So this is a progress. But I was mentioning that there is also the opportunity for right holders to opt out from this exception, which is, of course, I think, a major a factor of insecurity, and it's basically you give with one hand and you take it with the other. So one solution would be here to maybe interpret in a very restrictive manner and to put condition on this opt-out, for example, imposing formalities on right holder on this reservation, such as, for example, registration, but merely implementing like technical protection measure, that should not be sufficient to express this opt-out. Appropriate manner, this is a term that is used by the provision. There should also maybe include some sort of reasonableness of this opt-out. Maybe that could be appreciated, because if not, we will basically have like some sort of general opt-outs of all publishers from this provision, and it would never prosper. So two options: either we discuss it on legislative level, or courts start to implement it, and also maybe national legislator take the opportunity of the implementation in national law to be very restrictive on this opt-out. We could even think, in light of the directive on public sector information, that we would force, for example, public sector organization to refuse to opt out. So at least this would be a lot of data that would be available and not basically subject to opt-out. So reducing the opt-out is one solution, but it would not solve the issue in the long term.
So it has to be amended. Yeah, and I have also one other question here from the audience that actually says that, but whether or not autonomous generated works are protected, what effect do you think this technology will have on certain types of creations currently protected with a minimal level of creativity, such as translation, maps, and so on?
Well, we can answer the question. Sorry, am I on? Yeah, we can answer this question partly, at least, by looking at newspapers and news sources. So there's a very large increase in the use of so-called robot reporters, or something sometimes called automated journalism. And so a lot of the basic reporting, at least now it's fairly basic up to this point, is now done by machines. So of course the newspapers and news sources of other kinds are saving money, but those are journalist jobs that have disappeared. As the machines get better and better, that means more journalists get replaced. And I don't think I need to tell anyone on this call the importance of journalism and news in general in any kind of democracy. They're an essential part of the system. We're going to turn that over to machines. So the question is very good, because the impact is well beyond law. Obviously, it's a societal impact on. So journalism, it's clearly, it has started. In music, it's just starting, but it's going to increase. There might be some basic types of other works that will be created by machines. Machines are actually starting to write code for other machines, or changing their own code now. These are all creative jobs that disappear. So to me, that's one thing I think we need to think about. I don't have the answers, but I do want us to think about it before we start giving rights to all of that. And then, of course, we'll need empirical data. I'm looking personally at the area of journalism, because I'm particularly interested in that. I'm looking a little bit at music as well because I'm in Nashville, and well, it's still there's still a music industry. There's still people writing songs, but I think the question is really one that says, let's put this on everybody's radar, and I mean everybody who's interested in copyright, and see why are we creating incentives to accelerate this process without actually thinking down the road. That's the way technology develops, is all sorts of micro decisions made by individual companies and so on. And the technology develops and develops and it accelerates, and no one's kind of thinking where this is going. And I'm just saying it might be a good idea to think about this one, especially before we give legal rights to the things that are created by machines meant to replace humans at what we're supposed to be the best at, right? The thing that has distinguished us from other species up to now is no longer able to do so. And that's the kind of question I think we need to be asking.
I would like to add one point, because I thank you, Daniel, for putting journalists back in the discussion, because journalists is actually also a category of people which are totally excluded from the text and data mining exception, just for you to know. So basically all these scandals of tax evasions, remember the Panama Papers, where a journalist came up with massive tax evasions by basically text and data mining, doing text and data mining on millions of bank documents. This would not have been actually allowed under EU law. So here again, it's not about only these the difficulties that journalists are facing because they're replaced by machines, but there's also the difficulties they're facing by doing their job every day. We have seen also some problems when it came to reveal certain inside information and the conflict with trade secret law. This was taken very seriously at EU level with some exceptions. But here again, how can we have vibrant journalism if we nowadays do not allow journalists to text and data mining? I think this is absolutely absurd.
Thank you. Before it's actually time to close up, but still I have to ask the question about the one last question, and that will be about the automated enforcement, because I'm really curious about what you're thinking about Article 17.7 and 17.8, and as you know, on this platform, they will have some sort of AI system to actually hinder then uploading content, because otherwise they will be liable as principle, if I make it in short. But still, you should in member states law, in every member state's law should see that it's actually possible to use all the limitation and exceptions. So unprotected work you should be able to upload that, and you should also be able to upload, for example, criticism, parody, and so on. But do we actually have these sort of AI systems today that could sort out, so we could actually guarantee like freedom of expression?
Could you addressing?
You can start if you want, Christophe.
I'm happy to start, and then I hand over to Daniel, which I'm sure has also his view on this. Well, I've been very much spending a lot of time on this Article 17, as all copyright lawyers have done in the discussion on the directive, and after the discussion now in the implementation process. It's actually a nightmare provision. I mean, it changes the liability of platform hosting providers, which used to be not liable for the content that users were uploading on their platform, just to give a little bit of brief recalling of what we're talking about. And with Article 17, suddenly they have to basically do best efforts with regard to certain type of works that are communicated by right holders in order to avoid infringing content on their platform, and also in order to avoid that some infringing content is uploaded again after being taken down. This can only be achieved, and you just said it very rightly, Ulrika, by putting automated enforcement mechanism generated by AI. The thing is, with regard to this, and this AI would block basically uploads of users of certain copyright protected work. With, of course, the problem that you just mentioned, that this AI cannot recognize if this use is legal because it's covered by a copyright exception limitation, or it's an infringement. And I haven't found any literature so far which basically confirm the fact that these AI can contextualize these uses. So basically what we're looking here is that a problem of over blocking, over enforcement of copyright, because a lot of legitimate uses such as parody, user-generated content, maybe some quotations, maybe by journalists again, could be basically blocked, and a lot of users were prevented from expressing themselves and to sharing some information. So this is a huge problem, and the copyright directive says basically you have to combine these best efforts with this exception. You don't have to do general monitoring, but they don't tell you how this should be possible. Actually, it's an irresolvable conflict, and this conflict is now in front of the Court of Justice because Poland has questioned the validity of this directive with regard to fundamental rights. I think there is it's very likely, if the Court of Justice takes fundamental rights seriously, that at least some of the passage of this Article 17 will be declared as invalid or in breach of our EU Charter of Fundamental Rights.
Do you want to comment, Daniel?
Yes, very briefly. So if you look at what Christophe was talking about, the notice and takedown system, so that started up after the 1996 WIPO treaties. So we had the 1998 DMCA, the Digital Millennium Copyright Act in the US, and then the InfoSoc directive. But the process of notice and takedown was basically, if you're a copyright holder, you send a notice, the content that you object to because you think you own copyright in it and you think it's infringing gets taken down. And then the person who uploaded it can counter notice, and then you can have a debate as to, for example, whether it's fair dealing, fair use, or fits some other exception like parody. That was a human process at the beginning, very, very work-intensive process on the part of right holders and so on. Now it's automated. And I'll give you one example of parody that's quite probably famous even outside the US, the Pretty Woman case that went to the US Supreme Court. You had a district court, so first instance court, you had an appellate court, 3 judges, then you had the Supreme Court of the US, 9 judges, and many of them disagreed as to whether this was a parody or not. Ultimately, the majority of those judges at the Supreme Court said it's a parody, fine. But those are hard cases. Those decisions are made by humans. What happens with automated enforcement is whoever programs the machine, a program like Content ID or anything, to decide what passes as parody, for example, is extremely hard to do. First thing, I'll certainly agree with Christophe on that. And second, that person de facto is defining the legal standard, because who's going to take the burden on themselves to counter notice, to fight this in court? You would really want to have the funding for a test case to do that. There are very few of those cases. So basically this stuff will get taken down. And I think I'm not sure how to remedy that, but those people writing the code are writing de facto what the standard is.
Yeah, and I think this cannot be accepted this is my position, at least in a democratic society, that who decides actually on what is available online This reminds me of in the 2001 directive, there was these technical protection measure that were deciding actually like this anti-copy mechanism, what can be copied, what cannot be copied. So the answer in the machine is in the machine was the famous sentence by Charles Clark. I think we have some sort of history repeating with this directive in 2019. It's now automated enforcement. The hope is again in the machine to decide what should be online or should not be online, and basically it's some sort of a deal between big right holders and platforms that discuss among themselves what we can do online and what we cannot. And I think the Court of Justice has a great opportunity here to say, wait a minute, we're still here. There is still some democratic process here. I don't want to do this parallel, but it's of course obvious with the discussion that you have now in the US about Twitter shutting down the account of Trump, which has provoked a huge debate in Europe where many people have said, well, is it really for Twitter to decide, or maybe should it be a court, or should it be maybe some quasi-judicial system that decides on what can be said online or not? It's a bigger debate, I know, but there are some links to this copyright question.
Thank you. I think that we could debate this a lot more actually, and also if we look at the directive when it comes to the possibility for people that have not been able to upload and the measures that they can take. That's also very interesting to debate, but we don't have the time for this today. So I will thank you both for a very interesting discussion. Thank you so much, Daniel. Thank you so much, Christophe.
Thank you. Okay.
Thank you.
Thank you, Ulrika. I'm Manuel, taking the floor for a couple of minutes. Don't leave yet. Yeah. I guess you are tired after this intensive hour, but I can promise you that I'm exhausted. Yeah, completely exhausted. There's so many issues you have brought on the table, but probably you were not fully aware. Perhaps Ulrika was, but there has been a second line discussion along the questions and answers. Amazing, yeah. Be sure, please, that no single question will be lost. Yeah, we collect all of them. I have recollected more than 40. But the main issue today, and this is you merit, is not what you have brought, it's what they have brought. Yeah, and there has been extremely useful discussions, and this is food for thinking. Yeah, if I may recollect, and I try to take notes. Yeah. And I don't want to forget them, but I have recollected at least 15, 16 issues, which I would like to bring on board just to conclude. Yeah, the question is not the choices the machine offers, Daniel. Questions is the creativity of the choices. Yeah.
Mm-hmm.
Second, why machines' activity merit protection?
Mm-hmm.
It is exactly the contrary of a work for hire system. Copyright is about people. Look at history, please. Yeah, look at history. Yeah, and why the copyright system came. Yeah, and look at Victor Hugo, perhaps. Yeah. Number 4, careful with the sui generis rights. Once you create them, it is very difficult. I would say, Christophe, impossible to get rid of them. Yeah. Neighboring rights obsolete. Number 5, if we attribute rights to artificial intelligence, what is left for actual human creativity? Similar issue with patents, I would say. Yeah. the whole discussion of copyrights and patent come together here. We need incentivating, but for what? Do we need to incentivize machines? Is intellectual property the best tool to reward the activity of artificial intelligence algorithms? You see, you have brought so many deep questions. Yeah. What is the role of humans if the machines monopolize their creativity? We should rather focus on the future of creators who are suffering so much these days. Christophe, I try to bring to you clear, yeah? And where the copyright system is not properly protecting them. Number 10, we do need a better design of text and data exception, text and mining, data mining exception in Europe. And we need it precisely now. The example you have brought to the vaccines is very plastic, yeah. The Copyright Directive 2001 was the result of political compromises. And 20 years later, we suffered the consequences. I can testify that, Christophe, because I was there, you know. I was there and I was very, very, very aware of what the political compromises meant this day. But 20 years ago, we have no clue idea of what's going to happen, yeah, in 20 years. The same way we have no clue idea of what is going to happen in 5 years' time, probably now, yeah. Should we touch the laws, for instance, being more restricted with the opt-out, or should we leave the case law to develop by their own? And you tested also the difficulties of journalists facing today because the text and data mining exception do not apply to them, yeah. What about automated enforcement? Are creators really profiting from it? Yeah. You went also on the issue of the Copyright Directive and fundamental rights, precisely regarding Article 17. Yeah. And finally, who decides what is available online? Yeah. I think it was you, Daniel, who says, I don't remember who. The answer of the machines is in the machines was Clark, if I recall well, referring the Copyright Directive, and I will disclose here the dead decision on this article in 2001 was taken in a head of caps meeting in the Commission, yeah, where the legal service participated, yeah, and I can testify that I was present in a kind of chaotic meeting where the political feeling was much more important than the technical feeling. So all in all, this has been a terrific food for thinking. Thank you very much to you all. But if you may, if I may, most of all, this is not your merit, Christophe and Daniel. This is the merit of Ulrika. Yeah, it is so complex to bring a moderator in an active way, the way you have done it. Thank you very much, Ulrika. Thank you very much. And this is not the end. We come back in a month, and then we come back with Brexit and intellectual property. So you are all invited, cordially invited, to join us on the Wednesday, 10th of February. And then for the rest of the year, we have prepared splendid topics, yeah, full of energy and passion. We will continue with traditional knowledge and intellectual property. We will continue then with the plant variety rights and so on and so forth. Yeah. So thanks very much to all of you, Daniel, Christophe, and Ulrika. Now you are very welcome, invited to become part of our collegium of Encounters Collegium. Yeah, so you are part of the Encounters. I guess you have understood very well what's the spirit of this endeavor. This is not at all a webinar. this is a very alive discussion, and we were very, very proud with the work you have done today. And finally, very, very thanks to all of you. There were more than 500 people. There were hundreds and hundreds of people who will follow later on. And this is a way to bring food for thinking and discussion on the future of our beloved intellectual property to all over the world. We have attendance from more than 50 countries, and I am convinced that we will have more and more discussions, and what you have brought today is a great, great, great effort, and there will be a lot of students which will profit in the following weeks and the following months for the work you have done today. So Laurent, if you want to say something, it's fine. If not, I will close, and I will invite you all to the next 9th encounter, February 10th. Laurent?
Well, I would just say thank you to all of you, and again, thanks to our marvelous panelists who were with us today, and also to our splendid moderator who made shining this event that will be continuing. Professor Desantes, my friend Manuel Desantes, and myself, together with Javier Fernandez Asqueti, commit that there will be a reply to any question made in the chat, and also that we will continue to discuss all those topics we have discussed today more in detail, go into research avenues with all of you. Thank you very much, and all our warm wishes again for the forthcoming year, full of exciting global digital encounters.
Good. Thank you very much. Thank you.
Thank you all.
Thank you. See you next month.
Bye-bye. Have a nice evening, yes. You all, or morning.
Yeah.
Yeah.
Thank you.
Bye-bye.
Bye.
Bye-bye.